State Project live from the fortified compound in Mesa, Arizona. Glad to be with you here today. Everyone start filing in. And it's January 25th. I should write that down. I wrote it down. I won't get that wrong throughout the rest of this here show. January 25th, 2019. No, well, I made my first mistake of the show, 2020. It's one thing to make that mistake writing it, but I made the mistake saying it. So, hey, I keep a record of my workouts every morning. And up into just a few years ago, I had the book to actually show this, just writing the date down that I do every morning. I actually wrote, just a few years ago, I was still starting the date with 19. I really long for the late 90s. I really, really do. And if you lived through the 90s, you know, good times, good music, just good time. Welcome, everybody. And the audio should be cleaner. I can see that the audio should be cleaner anyway. And because now I'm back to doing everything, the entire show. One computer, well, it's been one, but it's all on Linux. And so I know that there's something with the drivers, the audio drivers on Windows, and I had to clean that audio up. I don't know how bad or how loud it was on the live stream, but I know it was definitely noticeable when I had my audio that I captured here, and because it's just on it's on Linux like it should be, I am not going to lose my audio because Windows sucks. Windows just sucks. So I didn't even get a chance to post the audio from last week's show. So hopefully today I will have the time to do that. But I wasn't even able to get that damn video of the success story. But I will get it. I will. If you want to join me on the show today, you can do so at 717-275-8941. I should have put this here where it's a bit easier for me to see. So can I get that? Yeah, you're gonna fight me. It's gonna fight me. 717-275-8941. That's 717-275-8941, and the passcode is 1233428. It is in the show notes. I remembered that much. So again, 717-275-8941, and the passcode is 1233428. You can still get me on Skype at Frank Rizzo 3. Is the number 3, Frank Rizzo 3. Please instant message me first. That's Frank Rizzo 3 on that there Skype. So that's another way to reach. You can also just post a question or a comment. I'll do my best as this goes to through the what do you call that? The YouTube chat. Hopefully it will stay clear of any trolls. And if there are people who are misguided, that we'll be able to reach them. This idea, the right to travel or the name in all caps, all that crap, that garbage, hopefully that's not going to rear its head today. But, we'll see. We'll see. And if you believe that stuff is true, if you're able to, give us a call here on the show and present your evidence. Because I've not seen any of them evidence. People have sent me stuff, and it just doesn't pan out. It's like one of these things going around still to this day about the Civil War. Civil War was over states' rights. It had nothing to do with slavery. It was states' rights to be slave states. They actually, it's this myth that just keeps rearing its ugly head. I know it had a lot to do also with debts, especially from the War of 1812. It had to do with federal debts and unfair taxation. But the main drive was slavery. So, They even said it. Jefferson Davis and other leaders, they actually said it was to preserve the institution of slavery because the Negroes' place, because they were inherently inferior to whites, their place was as slaves. They wrote that stuff. They said that stuff. That's what they believed and that's what they practiced. That non-whites weren't 3/5 of a person. They weren't as good. So, yeah, it was about slavery. Well, they wanted to keep slaves. That's for damn sure. So, all right. Number of things to get to. Let me check here. All right. All right. I did tentatively title the show about judicial notice. So thanks to Dr. Jones for bringing this up. I've mentioned this before about judicial notice, but I don't think I was necessarily as clear as I should have been, as I have been before. So he emailed me about that. And judicial notice, unless you are in California, and no matter where you are, judicial notice of a legal argument is never proper. So you could take judicial notice generally of adjudicative facts, right? Was Marc on Greenfield Road in Mesa on January 25th? That would be an adjudicative fact. Does the law require a payment of income tax if it goes above $600? That may be based on a law. They can take judicial notice. That's what the law says, not whether it applies to somebody, but what it says. That's in California. Or if there's a judicial ruling where the Supreme Court says that if there is a state law that seeks to convert a federal right into a privilege and tax it, that you may ignore the law with impunity. They could take judicial notice that was the ruling, not whether it is applicable, dispositive of this particular case. So generally it is of adjudicative facts. So it came up a number of times in the last few shows that judges taking judicial notice of not just legal arguments, but they're taking judicial notice of elements of the charge, which has to go to jurisdiction, personal and subject matter jurisdiction. Now, we've heard people report that judges are always saying that we cannot challenge jurisdiction at the arraignment or a pretrial, that jurisdiction is a trial issue only, that they have to prove it beyond a reasonable doubt or by preponderance of evidence at the trial. Now, that's true. It's not the only time they have to prove that, but it's the only time they have to prove it beyond a reasonable doubt. They still have a prima facie burden at the pretrial level or at the arraignment and pretrial level. So most statutes or rules regarding judicial notice do mimic the federal rule, which is Rule 201. Now, there might be some minor differences, but they're generally right on the money, word for word. Judicial, the title of the rule is a pretty big clue here that they're not supposed to take judicial notice of prosecutorial arguments. Judicial notice of adjudicative facts. See, I went through this with the IRS the other day. I think I mentioned it on the show, that they don't understand, or they pretend not to know, the difference between a statement of fact and a legal conclusion or a legal opinion. Whether somebody owes taxes, whether someone is a taxpayer, whether someone is a resident, whether there's a legal obligation created to file a tax return, those are legal opinions. Those are not statements of fact. A statement of fact would be Acme was forced under threat of jail to issue a 1099. That's a statement of fact. Now, whether someone's money is taxable is absolutely not a statement of fact. It is a legal opinion. You're applying the law to the facts. It's a legal opinion, not a statement of fact. So judicial notice of adjudicative facts. What kind of facts that may be judicially noticed? The court may judicially notice a fact that is not subject to reasonable dispute. not subject to reasonable dispute. So there's your objection if they're trying to do something like that. Because, the two things, they're trying to take judicial notice of something that is not an adjudicated fact, and and it is subject to reasonable dispute, which is why they say, I guess, jurisdiction's a trial issue, because it's something that it is subject to reasonable dispute. It is generally known within the trial court's territorial jurisdiction. You see, territorial jurisdiction, that the Constitution applies because you're in the territory, physical geographic area. That's part one. Part two is can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. Well, can the prosecutor be reasonably correct? Or in this case, let's say a tax case or a traffic case, can the police officers, as a source, can he reasonably be questioned? Yeah, which is why you're entitled to a cross-examination and a trial. Obviously, the police officer, as a source for anything, is reasonably questioned. Taking notice, the court may take judicial notice on its own. Now, that opens up a can of worms, because there are a lot of people that think that with no evidence whatsoever, none. How do I know? Because I've asked the people who claim that judges are taking silent judicial notice of things. So I would just ask the judge, sir, for the record, have you taken judicial notice of anything that is not disclosed explicitly in the record? Any examples where you've taken judicial notice, but you have not disclosed it? That would be a pretty serious, I would think, breach of due process, because due process requires notice and opportunity to defend. If the judge is taking judicial notice of something and he's not telling you, you can't possibly defend against it. Because as we see later in the rule, subsection E is opportunity to be heard. Upon a timely request, the party's entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice before notifying a party, the party on request is still entitled to be heard, but you've got to know. So every single time I have heard this, if it comes again up on the show, you know exactly what I'm going to do. I'm going to ask them, what proof do they have? Some reasonable, articulable suspicion, at least, right? Where is your fact? Where are the facts to prove that the judge is actually doing it? And what is he taking judicial notice of? Again, due process as a bare minimum requires notice and opportunity to defend. And that's why under the American system, it's hailed as being so great. It's because they have to disclose it to you so you can effectively defend yourself. This is not anything revolutionary. This is just basic stuff. So, come on. There's a point to this. There's always someone that's got to say something stupid just to get under people's skin. Talking about judicial notice, it's a pretty broad subject, and it's not a rant. I'm reading directly from it. What the hell is wrong with people? It's YouTube. Okay, so the court may take judicial notice on its own. Yes, but it has to have the facts. It has to be presented to them, and they have to disclose it to you. All right. Now, even though it doesn't explicitly say in Rule 201 that they have to disclose it to you, if you're entitled to question it, then you have to know about it. It's just common sense. The court must take judicial notice if a party requests it and the court is supplied with the necessary information. So when we're in traffic court or you're dealing with the IRS, the only information they're going to give the judge is their argument. Well, Your Honor, we think that the laws apply just because he's physically here in Arizona, and to take judicial notice of that. That's not an adjudicated fact. My physical presence in Arizona, yeah, that may be an adjudicated fact. But whether the prosecution's argument is correct, that fact proves the Constitution applies, which it absolutely doesn't. And of course, 717-275-8941. And the passcode is 123-3428. If you've got evidence that proves that my physically being in Arizona proves a 1910 written instrument applies to me and creates obligations, you're more than welcome to call in with your evidence. Yes, Joseph Smith is saying a natural person is the agent of the legal person. Black ink on white paper. You got to have some proof of that. You got to have some actual proof of that. Show that that kind of stuff. I don't understand. I don't get, and maybe Joseph, you can explain, what is the attraction of my show to you when I don't believe that stuff and I actively rail against that, and no matter how many times I've asked for evidence, no one can provide a shred of evidence that the natural person is an agent of the legal person. Wow. Well, let me get back to the I'm almost done with the judicial notice part. Timing. The court may take judicial notice at any stage of the proceeding. So that's pretty basic. It could be at the pretrial. It could be at the arraignment. It can be at pretrial. It can be during the trial. Opportunity to be heard. I've already mentioned this. Let's go into this a little bit more. This is our opportunity to object because, as we've already gone through, it has to be the accuracy cannot reasonably be questioned. It has to be an adjudicated fact, the accuracy of which may not be reasonably questioned. So anytime they're taking judicial notice, we've got to say the magic word, objection, and we've got to stop the process. And if the judge has already taken judicial notice, that doesn't mean that they are supposed to just continue. We make our objection and request the opportunity to be heard. Remember, on a timely request, a party is entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice without notifying a party, the party on request is still entitled to be heard. This would be properly described as a, I don't know. I don't know if there's a clear line here. If this is a substantive due process right, because they're providing the right they're creating the right. It's part of the process. But either way, it's definitely a due process right. Whether it's considered substantive or procedural, really isn't that important. But you're entitled to be heard. What if they don't hear it? There's your due process violation. You may have to bring that up on appeal, that the judge is taking judicial notice, not of an adjudicative fact, but of a legal argument from the prosecution. It doesn't matter what the propriety is or the validity of the legal argument. Legal arguments are not the subject of and the truth of them, especially on an element of the charge, are not subject to judicial notice. If the elements of the charge were subject to judicial notice, then the prosecution would just have to go in and ask for judicial notice of every single element. Just take judicial notice of it. Ignore, just like they do. They can just ignore your objection and tell you to Baba Fongo, you can appeal it and not even have a trial at all. And we had something similar happen basically up in Saskatoon, where a federal judge in Canada, in a criminal trial for tax evasion, found the guy guilty without a trial, just based on, I don't know if judicial notice was formally taken, but on nothing more than Meads versus Meads, said there's no need for a trial. The man is guilty. So I figured that would have been a slam dunk on appeal. I mean, you're talking about judicial notice of every single. We'll say he is relieving the prosecution of any kind of burden. He's just using Meads versus Meads as if that was evidence sufficient to prove every element beyond a reasonable doubt. Yes, legal opinions from something with completely different facts They denied somebody even a show trial. Even a show trial. Oh, come on, Joseph. There's a difference between a legal person and a natural person. A natural person is created in the image of God and can use logic and mathematics. Well, some would argue that those who are using logic and mathematics would not believe in a God. So I don't think any argument you've got that brings religion into it. I know I personally give it no credit whatsoever. I give it no merit. Won't even hear it. It's I won't even get into a moral or an ethical discussion with somebody if they're saying that religion is the basis of morality, because it's certainly and provably not. So I don't think your argument there, trying to invoke a God, I don't think that is a valid argument whatsoever. It's certainly not evidence at all on the claim that a flesh and blood natural person, as opposed to a person or a corporate person, like an LLC or a corporation or a trust, it's certainly, you're not presenting any facts just that a natural person like what I'm like me speaking now is an agent on behalf of a legal person, which the legal person is Marc Stevens in all caps. Something doesn't become a legal person or a legal entity just because you use all caps. It might be part of how you identify that, but that's not how it's created. You don't create a corporation simply by using all capital letters. There's articles of incorporation. There are documents you have to file. So just putting something in all caps is meaningless in and of itself. The only thing is it might be bad English. It may not be proper English, but it certainly is not evidence something's a corporation. It's not. That's just not the way things work. All right. So I think we covered the ground on the judicial notice. So if somebody is in court and the prosecution is asking for judicial notice, or the judge is doing it sua sponte on his own on his or her own motion, then you certainly need to use the magic legal phrase or a word, objection. And I say that because unless you use the actual word objection, it's not even enough to say, I take exception to this. You have to use the word objection, because I've seen in cases where people have reported to me about, and I've seen the documents, appellate courts can refuse to hear an appeal or an issue on appeal if the word objection wasn't used. So that's the way it works, unfortunately, with a lot of these judges. You just get in the habit of saying the word objection. So if they're going to take objection to something that is not an adjudicated fact, and that fact, and if it is a fact, if it is subject to reasonable dispute, then you have to say objection, and you have to press for your opportunity to be heard and make your argument, or have them argue that it is an adjudicated fact. The prosecutor has the burden, or who's ever asking for judicial notice, they have the burden of showing it is an adjudicated fact, not reasonably questioned. So if the judge says, well, then unfortunately you got an issue for appeal. And in what does happen and has happened, and was reported here, is when that happens to you, you have to know in advance. When you get to your cross-examination, they're not going to allow you to question the witness based on the judge taking judicial notice. So now you've got more evidence of the judge literally taking notice and of not just something that's not an adjudicated fact. He's taking judicial notice of a legal argument. He's taking judicial notice of an element of the charge you can't defend against. He's not going. So he's going to deny you effective cross-examination. He's not allowing a defense. He's taken judicial notice. You cannot dispute it. You weren't allowed to dispute it when you made your objection, you couldn't be heard when he first took the judicial notice. And then when you are at cross-examination, even despite the fact that the police officer or the tax agent has made those statements and their prior statements and relevant for cross-examination, the judge isn't going to allow it. You literally have a case of the judge prosecuting you or assisting in the prosecution. They're denying you an opportunity for a fair trial. You do not have notice and opportunity to defend at a meaningful hearing, because if he's taking judicial notice of elements of the charge and you can't question your witness, I think that's pretty much a no-brainer. That is a black letter law denial of effective cross and denial of a fair trial. So let us get to the calls. You think I'd learn my lesson, but I have no choice. I have to go really cheap and inexpensive with the headphones. So another pair of headphones. So that's why I'm lucky I even got to start the show today. I did not want to do the show where the caller line came through my speakers. So I had to run out and get the $4 special on the headphones. So we'll see how long. I'm sure they'll last at least for the duration of the show. So and they're not cumbersome, so I like that aspect of it. So what we're going to do, I will go to our first caller. We've got area code 667. You are live on the No State Project. What's your name? Where you calling from?
Hey, Mark. I've been calling before. This is Roy from Maryland. I moved to Virginia about, let's say, for Virginia.
Did you say it was Lloyd?
Roy.
Roy.
I called before. I called.
Right. I got it now. Yeah.
Okay.
Do you have good news?
No, my appeal is next week. But the judge, I'm trying to find a remedy because the judge basically denied my motion to remove the judge and prosecutorial misconduct. He denied both motions.
Did you press him for grounds, or do you not have the opportunity yet to do that?
I haven't had the opportunity to do it.
Okay.
Yeah, so I'm trying to figure out what's the remedy I could, what course I can go to, because I know basically they're setting me up to railroad me as soon as I go into the courtroom.
Well, when you said the appeal is next week, are you talking? You mean you have oral argument in the appellate court, or are you going in for a new trial?
I think it's an appellate court. I think it's an appeal because the judge. Remember, I told you a while ago that the first judge, he basically had due process violation. He told me I was past due process and wouldn't allow me to effectively defend myself because he kept picking up the burden of proof for the cop. And so I appealed it, and I'm into another court. This is the Court of Common Pleas in Pennsylvania. And basically, I just been sending motions back and forth with the judge. And every time I send the motions, it just keeps getting denied.
Well, I'm trying to figure out if you really have an appeal. Did you have a full-blown trial where the cop was on the stand and he did a direct examination, and then you cross-examined him? There were closing arguments, and the judge found you guilty, and then you appealed?
No, it was just it was like in some kind of little annex building, it looks like a courtroom, but it's not. It was like nobody there. It was just the judge, myself, and the cop.
Okay, but was there even an informal trial? I mean, did the police officer testify, and then you cross-examined and were found guilty?
Yeah, I did.
Okay.
I was able to ask some questions, but every time when I tried to ask the cop questions, the cop couldn't answer it. The judge stepped in for the cop.
What did the judge say for the cop?
He's like, basically, when I told you this before, when I asked him, did you file a cause of action? And he was like, the ticket. Everything was the ticket. And I was like, well, how many elements are in a valid cause of action? And all he kept referring to was the ticket. And that wasn't the answer I was looking for. And the cop couldn't really answer the question, so the judge stepped in and said, "Well, he answered your question. Anything else?" And I was like, basically, like, what factual evidence do you have that, because I was physically located in Pennsylvania, that the Constitution and laws apply to me? The ticket. Everything was the ticket.
Okay. All right.
And I was like, how does the ticket prove that?
Well, you got to remember what the logic, there's a certain logic that we're following here. And so we have to show the relevance, and we have to then build on that. And, so we're first asking that the police officer made such a legal determination. He determined that because you were physically in Pennsylvania, that there was territorial and personal jurisdiction to perform a stop and then write you a ticket. Then we ask him for the facts that's based on. Right now, if he goes to the ticket, instead of what you said, what do you think would have been a more effective? Now, because it's astounding that if you ask that question, that the judge will even allow an answer to the question. Because most of there's only been 2 reported cases in the whole time I've done this, that the police officer was able to answer the question. They did it up in we had a partial victory for Jermaine up in Canada, and in someone here in the United States a year or 2 ago. If he was allowed to answer the question and said the ticket, what kind of leading question or what kind of follow-up question would you ask the police officer on cross-examination to bring out that such evidence does not actually exist on the ticket? What would you ask him?
How does the ticket prove that your Constitution and laws apply to me? And where does it say on the ticket that this is evidence that you have jurisdiction over me? Well,
I wouldn't ask that. I would ask based on his prior statement. What facts on this ticket prove your Constitution applies to me, sir? Because he said the ticket was the evidence. Well, what specific facts on this ticket prove your Constitution applies and gave you jurisdiction? That would be the appropriate question.
Okay. Also, they have a video camera of me going across the light. But when I saw it, I'm like, well, they can't really make out that's me on a tape. They just saw a vehicle. So how do I defend against when they show the tape?
Well, anything that's going
that's what they're really going by.
Well, sure. Anything that is presented in court at a trial has got to be relevant, right?
Mm-hmm.
They have to show relevance. Remember, the 2 things that they're proving are that you are physically in Pennsylvania, the laws applied, and you violated them. Now, does the video prove the first part, that the laws apply? No. So, if you have no evidence yet that the laws apply, is it relevant to even discuss that you violated them?
No, it's not relevant at all.
No. So that's my argument, or that's my reasoning to object to
basically, when they show the video, okay.
Yeah,
so when they show the video, I can say objection. How does this video prove that that your laws apply to me?
Yeah, you could say objection assumes facts are not in evidence, or objection lack of foundation. It's not relevant yet. If and only if they first establish the first foundational part of their claim, that the laws apply because you're physically in Philadelphia, in Pennsylvania. If they're able to do that, then it's relevant. But it's not relevant until then. Relevant means it has to have any chance to prove the proposition. And so I already walked you through it. It does not have any chance to prove the proposition because you cannot, and they have not established the first part. So that's why I said there's 2 parts to that. The laws apply because I'm physically in Pennsylvania and I violate them. That's the 2 parts to their claim. The first part must be established before the anything for part 2 is relevant. I mean, I even walked the critic through that.
Now, what if they just like say, I'm a go and just steamroll me anyway, just to deny, don't even want to answer my questions and not just go ahead and steamroll me. And if I try to object, the judge threatened me with violence and contempt for violence and kidnapping. So because that's the kind of feeling I'm getting right now, because that's what they kind of setting up for.
Well, first of all, props on the pronunciation of your Italian there. So you said it like a paisan.
Oh, wow.
Do you know what it means?
Somewhat, yeah, I guess.
Well, I try to keep my language clean. And since I grew up, most of my swear words were in Sicilian or Italian. It's "abafangol" is an Italian "go f yourself."
Yeah, basically, I knew. I kind of figured it out.
So good on you. So that was good. So all right. So the question is, what do I can raise this objection. I can say this. They're just going to ignore it and they could overrule the objection, just steamroll over me. Is that possible? Hell yes. Is it probable? Yeah. We know that whatever the prosecution wants to put on, the judge is going to bend over backwards to give it to him. That's why people have reported here, and I've seen it personally, where every objection that they make is denied without explanation before you even finish saying it, and there's no input from the prosecution. But everything from the prosecutor before he even finishes the objection is sustained, and you don't even have an option. So it's totally one side. So we know that can happen. They're going to let it in there anyway, of course. So it's our job to destroy the perception on cross-examination. We have to, especially if we've got a jury, we have got to show it's not relevant, and we have to show that the police officer is making an argument he cannot support, and his lawyers are going to be the ones that say he can't support it, that he's not even competent to support it. So again, regardless of what critics will say, that we can't challenge their claim that the Constitution applies because we're physically in Arizona. We can't challenge that. We have to accept that they can only go to the law, that somehow that my challenging it is political and outside the jurisdiction of the court because they only hear legal questions. I disagree with that, because if the police officer, see, what's important for you or any of us in the situation, Roy, is what is the prosecutor alleging against you? What is the cop alleging against you? Nothing else matters. So your job, our job, if we want to effectively defend ourselves, is to address the argument and the claim that's actually being made. So that's why we get the police officer to restate what happened at the stop. So regardless of what someone on YouTube says, when the police officer, when you ask him, and this should always be the first question, did you determine on your own that just because I was physically in Pennsylvania that your laws applied and giving you jurisdiction? Now we know what their claim is. Now we can attack it, and we should be doing that. And if they're not going,
so as a cop first, did you make a legal determination that when I was in Pennsylvania that your laws apply when you stopped me?
I wouldn't put it to him in that. I wouldn't use those words. I would take some of the words out. I would just say, Mr. Police Officer, did you determine on your own that just because you saw me physically in Pennsylvania that your laws applied, giving you jurisdiction and probable cause? And then he'll say yes. Okay. Now remember, the Constitution is the basis of their law. It is a law. So I'll use it in a broad sense. I need to get that admission from him. And then once you have the admission, you can attack it. So I'll say, even though the information or the questions regarding a valid cause of action are in the script, I've said for a long time, it's not something we get into anymore because we generally don't have the time. And it's a lot more effective just to hammer away at the foundational claim of the police officer, which is, dude, I saw you in Philadelphia. I determined on my own that the laws applied. and that gave me jurisdiction and probable cause to stop you. And then we,
Okay.
So
I'm
that's the
gonna
focus.
play this. I'm gonna play this section back so I can write down the questions, write them down more effectively, so I can ask them the right way.
Yeah, and someone's saying here that is what the cop's training and experience tells him, but you have to have the facts. So through your experience, through all this, what facts did you rely on? Or are you just doing it based off of what someone told you? Making a determination based on what someone told you is not personal knowledge and doesn't prove the proposition. It doesn't prove it's true.
Okay. Now, suppose the prosecutor steps in and says that the cop is not what's that word? The C word I'm looking for. Not capable of answering the question, or not I forgot the word.
He's not qualified or competent to give legal conclusions.
Not qualified. So basically, if the prosecutor said the cop is not qualified, I can say objection. 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 I move the case to be dismissed due to the fact that cop is not qualified. That means the ticket and the video is null and void.
Well, I would take things one step at a time. Don't bite off too much yet. Okay, it's a big leap, and anytime we go to dismiss, there's a reflexive denial. We have to get, once let's say they make the objection, the witness isn't qualified to make that determination, and the judge sustains it without any input from me or you, or from whoever it is, right? We obviously say the word objection. Objection, move to strike all of the police officer's legal claims, since you just held he wasn't qualified to make them. And that includes his determination of jurisdiction and probable cause. See, that is exactly what happened, Roy, in the what happened here in with Rebecca, where they sustained the objection, even though it wasn't calling for a legal conclusion, right? See, all the stupid comments are about me trying to say that the police's legal determination or legal claim, all right? But instead of focusing on the fact that the one who's really mischaracterizing is the prosecution, saying that my question for facts required the police officer to give a legal conclusion, which only judges apparently can make. So, what happened with Rebecca, she was able to argue and get a damn acquittal on one of the two charges. She got an acquittal, everybody. She was able to argue right in front of the jury that if the police officer was not qualified to make such legal determinations, such as probable cause, which is a legal determination, it is a legal determination, that his testimony, all of his legal determinations should be stricken because he wasn't qualified according to his own lawyer and now the judge who made it the law of the case. And the jury got to hear that. It didn't, she argued, of course, that I didn't ask for a legal conclusion. She made that clear. I didn't do that. But the judge didn't give a damn. But the jury gave her an acquittal. There were 12 people who voted for acquittal on that charge. So apparently it got through to them to realize, yeah, she's right. The prosecution said the witness wasn't qualified to determine probable cause. And if you can knock out this finding a probable cause, if you can knock out the rest of the legal claims, then the whole case falls. Okay.
All right. Thanks, Mark. But let's just say, I did all that, and because I don't know if there's going to be a jury there or not. But let's just say if there's no jury there, and and I'm doing the right thing, and the judge sustains all the prosecutor's objection, including him not being qualified, and they try to steamroll me anyway. What else I can do?
There's nothing you can do other than object, because I'd be shocked if there was a jury there, especially since you're saying it's an appeal, because it might just be oral argument where you're presenting your argument why due process was violated. Your facts, you have to have your facts to support your legal claim that due process was violated. So you have the judge stepping all over your effective cross-examination. So you bring out that my questions were relevant because they went directly to prior testimony. If there is a jury or if there is a new trial, all you can do is make your objection. You object once. You don't just keep objecting, and you never talk over the judge or the prosecutor. That's the best you can do. I mean, if you can have the judge not allow an answer to a question where you're trying to elicit the facts the police officer's determination was based on, that's a denial of cross-examination, effective cross-examination. And if they're not going to reverse, or if they're going to find you guilty anyway, and they will not reverse on petition for post-conviction relief, your only option is to appeal it. And then you'll have to argue and show your facts to support your legal claim, why you believe that you were denied an effective cross-examination. So you'll have to show that the questions you asked were relevant to a valid defense. Okay.
All right. Thanks, Mark. I hope for the best next week.
Well, good luck. And I appreciate the call. If there's any other questions, you can call on the Wednesday show if that's before, or just, you can email or Skype me any questions. But I do wish you luck, and I hope you got some good news for us next time.
I will. All right. Thanks, Mark.
Appreciate it.
All right. No problem.
That was Roy in Virginia. And, so if you're going through a similar thing, we always have to look at a worst case scenario. You have to lay out what, if this, then what? You got to have some kind of remedy. And sometimes it comes down to your only remedy is appeal. If you're in this situation where the judge is going to allow the prosecutor to make an objection that is clearly off, it has nothing to do. So you ask, did you make determination XYZ? Yes, the cop says, or whoever the witness is. Okay, now you've got a statement under oath that he's made. He's confirmed what he did at the stop. If you follow that up with what facts did you rely on to support XYZ, and the judge doesn't allow it, he's stepping on your cross-examination. What he's also doing is allowing a very serious ethical violation by, I don't want to hear any of your stupid claims. You can't talk about ethics in the context of a legal proceeding, because that's bull. That's absolute bull. You absolutely can, and that's why I've mentioned before, prosecutorial misconduct is an ethical violation. Getting a judge recused goes to the judicial canons of ethics, the judicial canons of ethics, the judicial canons. So spare me this crap, all right? I'm going to go through the evidence here why you can do that. So when a lawyer does that, they're making a false statement. They're clearly making a false statement, because I'm asking a question, asking for facts, and they are making a false statement through their objection, in that they are saying that I'm asking a question that requires a legal conclusion, which is not what's going on. So if we look at the ethical rules, now I'm going by the ABA, the American Bar Association model rules. And that's just for general application. They may be slightly different in California. The number might be might be different in California and maybe a couple of other places. But generally, the state bars do have these rules. They're almost identical. They're almost word for word, and they generally follow the numbers. So if you go to Rule 3.3, again, this is the ethical rules. These are the model rules of professional conduct. These are the ethical rules. So it states that a lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. See, this goes right to, I wanted to discuss this because of what Jay Sekulow and the impeached President Trump lawyers are saying in his defense. So, but I'll get to those people in just a second. And do we have, probably not. All right. I think what I'm going to do, I don't think we're going to get any more callers today, and I'm running pretty low on time. So what I'm going to do is I will drop off the caller line. So if anything, we may have a Skype call there. So again, if you want to Skype me and join the show, it's Frank Rizzo 3. So if we look at the ethical rule there for lawyers, they shall not knowingly make a false statement. Now, some lawyers may claim if you object and move for sanctions for the obvious false statement, they may, they'll make some argument and say, well, I didn't knowingly do that. I don't think that has any merit at all. When right in your question, you say what facts, and they say objection calls for a legal conclusion, they are making a false statement of fact or law to the tribunal. They are lying. They're lying. And I would object and call them out on it. It's not an on-point objection, and it's done deliberately. They know it's false, and they do it anyway. And they do it because they know they can get away with it because the friggin' judge doesn't care because he's on the same team as the prosecutor. They're both representing the state. And through his actions, you can see he's carrying the prosecutor's burden. Any judge that had any integrity whatsoever, that had any honesty whatsoever, when they make that objection, and this has never happened before, when they make the objection calls for legal conclusion, and you clearly ask for the facts. Any judge with any integrity or honesty would say, overruled. And I would caution them, you make another off-point false objection like that, and I'm going to have to hit you with sanctions. That's what an honest judge would do, and would direct the witness to answer the question immediately. But because you are questioning the foundational claim that the prosecution has admitted is the claim, and that you have prior statements to confirm, notwithstanding what somebody says on YouTube, okay? We're going by what's actually happening on the ground on the battlefield, okay? That's all that matters, is what the prosecution is actually claiming. So if they are making a claim that they shouldn't be, let the YouTube legal gurus, let them correct them. I don't care. I'm going to address what they're actually saying. So anyway, I would call them out on that, and it's something that it could and it should be a part of this scam. This what is a hoax is what's going on in the Senate right now, where you have people who took an oath to be impartial, and there's video proof of them saying they have no intention of being impartial. That's supposed to be perjury of your oath. You just committed a felony. And also committing felonies where, even if we're not going by the ethical rules, which I'll get to in a second, Title 18, Section 1001, that would make it a felony to utter a false statement in the jurisdiction of the Senate or the Congress or the executive branch or the judicial branch. You don't need to be under oath for it to be a felony, to make a false statement, knowingly make a false statement for it to be a felony. Title 18, Section 1001, false statements. But here in this hoax, this sham of where they're not even going to have new evidence, and they're not even going to have witnesses, where they've already determined they're going to acquit. You have the impeached president's lawyers going in and lying and lying and lying and lying again, and called out, at least superficially, by Chairman Nadler, Jerry Nadler of New York. And instead of John Roberts, instead of admonishing and warning Sekulow, the other one is is actually Italian. I hate to, well, hopefully he's just Italian. He's not Sicilian. It would be really embarrassing if he was also. He probably isn't Sicilian, but he's probably Italian. And he should be cautioning them that they are, by making such false statements, such as that the impeached president, Donald Trump, was not given due process in the House proceedings because he was not allowed to cross-examine witnesses when he was able to. The Republicans were able to, and he was able to do that. It's just like the lie that the Democrats who followed the rules and did it in the basement, the 2005 Republican rules, that no Republicans were able to participate when all the members of those committees were there and had equal time to question witnesses. So John Roberts, if there was integrity there, well, a lot of us have probably read Citizens United, and we know John Roberts is not really the most principled guy. Should have warned and reminded Sekulow and the other attorney for the impeached president, Donald Trump, that a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Instead, they get away with it, and they admonish them. They admonish even someone like Jerry Nadler for calling out the lie for decorum. No, he's lied. In fact, what someone like Nadler should do is just read the ethical rule. A lawyer shall not make a false statement of fact or law. To say that the impeached president, Donald Trump, was not given due process because he was not able to cross-examine witnesses is false. Also, the House proceeding is like an investigation and an indictment. And in no circumstances, when you're being indicted, you get to cross-examine witnesses. You don't get to cross-examine witnesses until you're at trial. So it just, what a sham. What a sham. So if there is a hoax, it's what's going on with the Senate. So let's see. The hearings this morning, I did not get a chance to see much of the hearings this morning. So I do know it is disgraceful. If there was not going to be a trial, it should be to remove him, vote to remove him. That you don't need a trial for, because the evidence is overwhelming. And the guy admitted it. And he continues to admit it. He even said over in Europe at whatever the Davos thing that's going on, he actually admitted he has all the documents. They don't have the doc. We have all the He's admitted to withholding all the documents. And saying it's a witch hunt, sorry, just saying it's a witch hunt doesn't excuse obstruction. So anyhow, someone saying Trump wasn't given due process in the House. That's not true. And he was invited. He and his lawyers were invited to participate. They didn't. I don't know where if somebody's saying, all right, here's the thing. If somebody's saying he was denied due process, at least have the common courtesy to say exactly what specific due process right he was denied. Because he certainly wasn't denied the right to cross-examine, because the House was able to do that, and his lawyers were invited to the hearings so that they could have cross-examined witnesses also. So that part isn't true. So what other part of due process does one of these Trump guys think that he was denied? What specific? So what is that? I'm trying to. Oh, come on, Steve. Well, no, it's Stevens. It's come si chiama Marco. It's Marc Stevens. Don't try to claim the demented Krats have been unbiased when from day one they said they were going to impeach Trump. Well, actually, if you go back, you can see from day one the Republicans were talking about impeaching Hillary. But even if somebody was saying about impeachment, from day one, he started violating the emoluments clause. That's impeachable. So I don't see where their presentation of the evidence is biased. I haven't seen that, but there was one claim here I wanted. No, I guess yeah, all right. I can't see. Well, there was a comment there I wanted to. Oh, here it is. Yeah, I'm an anarchist, but I side with the effing super statist. F off, unsubscribes. That was Pat Starr's. I'm not siding necessarily with state. I'm siding with the evidence, and I'm showing. I just see that what's going on is a sham, and it's the lies, and I'm just calling them out for the lies. I don't want this idea that I didn't criticize Obama. Wow, that's just not true. Obama is a war criminal and should be in prison the rest of his life. Maybe, but that's not going to happen. I started criticizing him right from the very start because one of the first things that should have been done was George Bush should have been put on trial for war crimes, and he wasn't. This crap. We've got to let the country heal. Come on, let the country. You heal by holding them accountable. That would be like having someone like Henry Lee Lucas or Ted Bundy. We've got to let the people heal. We can't start prosecuting people for what they did because we've got to let people heal. So I came after. I criticized Obama for the crap that he pulled. Also, this is just another. But the difference here is just how over the top the corruption is. But so spare me this crap that I'm a liberal and I don't criticize the libtards. My position is not based 100% on the fact that I hate liberals so much that I'll excuse the horrible things that Trump does. Well, they're all bad. But if they're all bad, then why hitch your wagon to Donald Trump? I don't get it. And there's this stupid false notion, well, Democrats are communists. No, they're not. Some may actually be, but someone like Bernie Sanders is not a communist. It's just throwing words out. You gotta. Anyway, I don't want to get into that. We've covered a lot of good ground here on the show. Hopefully, we got some good news from Roy when he calls in next time. And if you're being attacked by a bureaucrat and you want to learn how to more effectively defend yourself, go to markstevens.net. Look at the evidence at other people, the evidence of where so many of other people from all over the U.S. and Canada, Australia, New Zealand, and England that have been able to replicate the success. And yes, I will do my best. I said the last time, so I can't say take my word for it, but I will be working on getting the new success story video and article up at markstevens.net, where we had another success story in New York where, no, it wasn't because the cop didn't show up. The prosecution once again withdrew. I think I have at least as many prosecution withdrawals as we do the cop not showing up. So anyhow, if you want to effectively defend yourself, markstevens.net. Use the Socratic method. Be a skeptic. Don't take what these people say is true. Challenge it. And something is not true just because someone on the internet says so. And that goes double for me. Have the evidence. But I can tell you this, if I'm making a claim, I damn sure, especially on the air, I damn sure have done my homework and I have my facts. Those facts may prove to be wrong later and I'll correct, but I will certainly have my facts straight. So be skeptical. Always disbelieve. Whatever comes out of their mouth, don't believe it until there's facts to prove it. Again, my name is Marc Stevens. The website, markstevens.net. If you want to support the show, you may do so there and at markstevens.sells.com. So for this January 25th, 2020 show live, I appreciate you tuning in. Until Wednesday when we're live again, salud.